The officer who snapped the handcuffs onto my wrist was young, maybe 26, 27. He had that tight-jawed seriousness that rookies wear when they want to look like they've done this 1,000 times. He hadn't. I could tell by the way his hands trembled slightly as he ratcheted the cuffs down, just a hair too tight, just enough to remind me they were there. I didn't say anything about that. I stood on my own front porch, in my own neighborhood, at 11:17 on a Tuesday night, and I let it happen. The street was quiet except for the low idle of the patrol car in my driveway and the distant bark of someone's dog 3 houses down. The porch light was on. Moths circled it. Completely ordinary. Completely surreal. My wife, Claudia, stood just inside the doorway in a gray cardigan I had bought her 2 Christmases ago. Her arms were crossed. Her eyes were wet. She had this look on her face that I can only describe as devastated, brow creased, lip trembling, the whole performance. And she was so good at it that if I hadn't known exactly what she'd done 3 hours before that moment, I might have believed her. But I didn't know. So I watched her the way I used to watch witnesses on the stand. Steady, quiet, cataloging every micro-expression. And just once, just for a fraction of a second before she turned her face away, I saw it. The corner of her mouth. A twitch. Not grief. Not guilt. Satisfaction. "Mr. Calloway," the young officer said, his hand on my arm. "You're being detained on suspicion of domestic violence and assault. You have the right to remain silent." I knew those rights better than he did. I had written sentencing memoranda that cited case law going back 40 years. I had stood in federal courtrooms and argued constitutional protections that most law school graduates couldn't locate on a good day. I had prosecuted men far more dangerous than anyone in this quiet suburb had ever seen, and I had done it for 22 years before I retired. My name is Nathaniel Calloway. I am 54 years old, and my wife had just made the worst mistake of her life. Let me back up, because to understand what happened that night and what happened in the weeks after it, you need to understand something about the life I had built and the woman I had built it with, and how completely I had allowed myself to stop seeing what was right in front of me. I grew up in rural North Carolina, the son of a Baptist preacher and a woman who taught 2nd grade and believed with her whole heart that education was the only door worth walking through. We weren't poor exactly, but we weren't comfortable either. There were years when my father's congregation was generous and years when it wasn't, and I learned early how to read the financial temperature of a household from the way my mother set the dinner table. Cloth napkins meant things were okay. Paper towels meant they weren't. I got a full scholarship to UNC Chapel Hill. Went to law school at Georgetown on another scholarship. Graduated 3rd in my class. Clerked for a federal judge in the 4th Circuit for 2 years, and then joined the United States Attorney's Office for the Eastern District of Virginia at 26 years old. Youngest hire in the office's history at that time. I was good at it. Not in the glad-handing, politically ambitious way that some prosecutors are good at it. The ones who are already thinking about their next career move while they're still in opening arguments. I was good at it because I was meticulous. I was patient. I had this ability to sit with complexity and not flinch, to hold 100 contradictory details in my head simultaneously and find the one thread that connected them all. I tried serious cases. RICO cases, public corruption, organized crime, federal drug trafficking. I put people in prison who had never expected to see the inside of one. And I did it the right way. No shortcuts, no manufactured evidence, no coerced testimony. If the case wasn't solid, I didn't bring it. By the time I was 40, I had one of the highest conviction rates in the district. By 45, the governor's office had approached me twice about a federal judgeship. I declined both times. I wasn't done yet. There were still cases I wanted to try. I met Claudia at a charity gala in 2009. She was 32, recently divorced, working as a real estate agent, and she had this quality that I was completely unprepared for. She was funny. Not performatively funny, not trying to impress funny. Just genuinely, unexpectedly funny in a dry, deadpan way that caught me completely off guard. We talked for 2 hours at that gala. I asked for her number at the end of the night, and she gave it to me like she'd been waiting for me to ask. We dated for a year. We got married in 2011. We moved into a house in a good neighborhood in Northern Virginia, comfortable without being ostentatious. We had a dog named Horace. We had Friday night dinners at a little Italian place on the corner that knew our order before we sat down. For about 4 years, we had a genuinely good life. I should tell you when things started to change. because they didn't change all at once. That's never how it happens. It's always gradual. It's always degrees. The first thing I noticed was the money. Not that she was spending too much. Claudia was actually careful with money, sometimes pointedly so, in a way that occasionally felt like commentary. What I noticed was that she had started paying more attention to it. To my pension, specifically. To the federal retirement benefits I'd been accumulating for 22 years of public service. She started asking questions, almost casually, that I now understand weren't casual at all. How much was the monthly figure going to be? Was there a survivor benefit? What happened to it if we divorced? I remember answering those questions with the comfortable openness of a man who doesn't recognize that he's being mapped. The second thing was her absences. Not prolonged ones. Not dramatic disappearances. Small gaps. Hours that didn't quite add up. A showing that ran late. A client dinner that extended. Nothing that would ring an alarm on its own. But when I started putting the gaps together, they had a rhythm. Every 10 days or so. Regular as a tide. The third thing was a name. Detective Raymond Holt. She mentioned him the first time in the spring of 2023. Offhand, we'd had a neighbor issue, a property line dispute with the people next door, and she said she'd been talking to someone she knew at the county sheriff's department who might be able to help smooth things over. Raymond Holt. She said he was just a contact, someone she'd met at a neighborhood watch meeting a few years back. Very helpful, she said. Very connected. I nodded. I filed it away. 2 weeks later, she mentioned him again. I'm a prosecutor. I know what it means when a name appears twice. But I still didn't act. Not yet. Because the thing that 22 years in law does to you, if you're a good lawyer, is that it teaches you not to move on suspicion. Suspicion is the beginning of a case, not the case itself. You need evidence. You need a theory that survives scrutiny. And you need to understand exactly what you're dealing with before you show your hand. So I watched. I want to be precise about what I mean by that, because I wasn't obsessive about it. I wasn't following her or interrogating her or living in a state of frantic suspicion. I was just paying attention, quietly, methodically, the way I paid attention in courtrooms, listening for the details that didn't fit. Over the next 3 months, they accumulated. In June, I noticed that Claudia had opened a new email account. I found it by accident. Her laptop was open on the kitchen counter and a notification came up from an address I didn't recognize. I didn't read the email, but I remembered the address. In July, she mentioned that she'd been talking to a lawyer about general financial planning. The name she gave was Marcus Whitfield, an attorney I happened to know by reputation. Not for financial planning. For high-conflict divorce litigation. He was one of the most aggressive family law attorneys in the state. That one landed differently. I sat with that one for a while. In August, she started sleeping on her side of the bed with her back to me in a way that was different from before. Not cold exactly, but deliberate. Like she was practicing a distance. Like she was already rehearsing being somewhere else. And then in September, I found the recording. Not a recording she intended for me to find. A voice memo on the kitchen Bluetooth speaker that had auto-synced to a shared household account she had apparently forgotten I had access to. A 2-minute and 43-second conversation between Claudia and a man whose voice I recognized immediately because I had trained myself for 22 years to remember voices. Raymond Holt. I'm going to tell you what they said, not word for word, because some of it matters for reasons I'll get to. But the substance of it. They were discussing a plan. A specific, detailed plan. The kind of plan that doesn't get built overnight. The kind of plan that requires coordination, timing, and the kind of cold calculation that most people aren't capable of, but that both of these people clearly were. The plan was this. Claudia would call 911 and report a domestic violence incident. She would claim that I had grabbed her, shoved her into a wall, and threatened her. She would have visible bruising. She mentioned this in a calm, almost administrative way that made something go cold in my chest, which she had apparently already arranged for by some method she didn't detail in the recording. Raymond Holt, who had apparently been her lover for at least 8 months, and who had apparently been feeding her information about how domestic violence reports were processed in their jurisdiction, would make sure that the responding officers were the right ones. Officers who wouldn't ask too many questions. Officers who would follow procedure exactly and document exactly what she told them. Once I was arrested, Claudia would file for an emergency protective order. I would be removed from the house. Marcus Whitfield would file for divorce within 72 hours, while I was still processing the arrest and before I had time to secure proper legal representation. He would file motions freezing joint assets. With an active domestic violence arrest on record, the court would be predisposed against me in any immediate hearings. By the time I got my bearings, the narrative would already be established. Nate Calloway, former federal prosecutor, domestic abuser. The irony of that, the optics of it. A man who spent his career prosecuting violent offenders accused of violence in his own home would be devastating. Professionally, reputationally, personally. She would get the house. She would get the primary financial assets. She would likely get a significant portion of my federal pension. And Raymond Holt, who had apparently been working through a complicated and moderately illegal financial situation of his own that I wasn't yet fully aware of, would get a partner who had just secured a very comfortable future. I listened to that recording 3 times. Then I sat at the kitchen table for a long time in the quiet of the house, and I thought about the life I thought I had. The Friday dinners. The dog. The woman in the gray cardigan who had made me laugh the first night I met her. I thought about how long she had been building this. How she had looked at me across that dinner table 100 times while she was planning it. How she had said goodnight and kissed me on the cheek and turned off her bedside lamp, while this entire architecture was taking shape in her head. There was grief in that moment. I want to be honest about that. I'm not going to pretend I sat there cold and tactical and unmoved. I was devastated in the quiet way that grown men are devastated. No dramatics, no visible collapse, just this deep, hollow, settling feeling like something structural had given way. But grief is not a strategy, and I had a lot of work to do. The first thing I did was not panic. The first thing I did was think. I am a former federal prosecutor. I know how evidence works. I know how cases are built and how they fall apart. I know exactly what Claudia and Raymond Holt were counting on. That I would be caught off guard, that I would react emotionally, that I would make noise and threaten lawyers and do all the things that guilty men do, all the things that innocent men do when they don't know how to defend themselves. I wasn't going to do any of that. The second thing I did was call an old friend. His name is Gerald Whitmore. We went to law school together. He went a different direction than I did. Private practice, civil litigation, eventually federal defense work. He is one of the finest legal minds I have ever known, and he is constitutionally incapable of being rattled. I called him at 7 in the morning on a Wednesday and told him I needed to meet that day. He heard something in my voice and didn't ask questions. He said to come at noon. I sat across from Gerald in his office on the 14th floor of a building in downtown D.C., and I laid out everything I knew. The voice memo, the timeline, Raymond Holt's identity and role, Marcus Whitfield, the probable charges, the probable timeline. Gerald listened without interrupting, which is one of his great skills. When I finished, he was quiet for a moment. Then he said, "How long do you think you have before she moves?" I said I didn't know. A few weeks, maybe. She was still in the calibration phase, making sure everything was in place. He said, "Then we have a few weeks." We spent the next 4 hours at that table mapping out everything I needed to do before she pulled the trigger. Here is what I want you to understand about those weeks. Because it's easy, when you're telling a story like this, to skip the middle, to jump from the discovery to the resolution and leave out the grinding, meticulous, often exhausting work in between. But the middle is where the case is won or lost. Any prosecutor will tell you that. I started with Raymond Holt. I had his name. I had his voice. I started pulling everything that was public record. And there's a lot that's public record when you know how to look. Property records, court filings, professional disciplinary records, financial disclosures. What I found in the first week was interesting. What I found in the second week was explosive. Raymond Holt had a problem. Specifically, he had a gambling problem that had been quietly bankrupting him for the better part of 3 years. He had taken out loans against his home. He had credit card debt in the high 6 figures. He had 2 civil judgments against him from creditors that hadn't yet been satisfied. And, most relevantly, there was a quiet internal affairs inquiry at his department, not yet public, not yet formalized, related to missing evidence in a narcotics case. I found that last piece through a contact of mine in the state attorney general's office, a woman I'd worked with on a joint task force 10 years earlier. I called her with a carefully worded inquiry, and she called me back 20 minutes later with a confirmation and a very pointed question about why I was asking. I told her I had a situation developing and I would keep her informed. She told me to be careful. I told her I was always careful. The third week, I hired a private investigator. I want to be clear that I was not building evidence of Claudia's affair for emotional reasons. The affair was almost beside the point. What I needed was documented proof of her relationship with Raymond Holt, because when his role in the conspiracy came to light, the nature and depth of that relationship would be relevant to the criminal case. I needed a paper trail that connected them, that established duration, that established the kind of sustained contact that would make a jury understand this wasn't impulsive. This was planned. The investigator, a retired FBI surveillance agent named Portia, delivered exactly what I needed within 10 days. Photographs, time-stamped, hotel records, text message logs obtained through legitimate means I won't detail here. 8 months of a relationship that Claudia had conducted with a specificity and a carefulness that would have impressed me in a different context. I also, during this period, did something that might seem obvious but that I think a lot of people in my position would have failed to do. I preserved everything in multiple locations. The voice memo, copies on 3 separate encrypted drives, one in a safe deposit box, one with Gerald, one with Portia. Everything the investigator had gathered. My own notes, which I had been keeping in a legal pad in a locked drawer in my office at home, and then photographing and sending to a secure email account Claudia had no knowledge of. I built the kind of redundancy into my evidence preservation that I had always demanded from investigators who brought me cases. Because I knew from experience that evidence has a way of disappearing when powerful people have an interest in making it disappear. And Raymond Holt, for all his financial troubles, was still a sitting law enforcement officer with access to systems and processes that could make things inconvenient. He was not going to get the chance. The 4th week, I reached out to someone else. Her name was Deputy U.S. Attorney Sandra Mears. She had taken over the Eastern District Office after I retired, and she was exceptional, rigorous, fair, exactly the kind of prosecutor the office needed. I had mentored her briefly when she was starting out, years ago, and we had stayed in loose professional contact. I called her, met her for coffee, and without telling her everything, I couldn't yet. The case wasn't fully assembled. I asked her a pointed question about how her office would handle a law enforcement officer engaged in evidence tampering and conspiracy to file a false police report. She looked at me over her coffee cup with the particular expression that sharp prosecutors get when they sense something large approaching on the horizon. "Why are you asking me that, Nate?" "I'm asking hypothetically. You've never asked anything hypothetically in your life." I smiled. "Soon," I said. "I'll have something concrete soon." She said, "When you do, don't wait." She didn't have to tell me twice. The night they came for me, I was ready. I knew it was coming that week. The signs were all there. Claudia had become slightly more careful around me, slightly more deliberate in her warmth, the kind of warmth that people perform when they're trying not to tip their hand. Raymond Holt had apparently gone quiet on the internal affairs matter, which my contact told me meant it had been resolved in his favor, which meant he felt secure, which meant the timeline was probably closing in. On the Monday before it happened, I spent 4 hours with Gerald going through everything one final time. He had prepared a motion that was ready to file at a moment's notice. I had given copies of the complete evidence package to Sandra Mears, sealed, with a letter instructing her to open it upon my arrest. I had spoken to Portia and confirmed that she was available and reachable at any hour. I was also, I will admit, exhausted. Not afraid exactly, but that particular kind of tired that comes from carrying a weight in silence for weeks. From sleeping next to someone who is planning to destroy you and not letting them see that you know. I had done versions of this in my professional life, maintained a composed exterior while everything churned underneath, but never with this kind of personal stakes. Never in my own bedroom, in my own life. On the Tuesday night, I was in my study reading when I heard Claudia on the phone in the kitchen. The walls in our house are not thick. I heard her voice drop, heard the specific quality of her cadence shift, the way it does when someone is having a conversation they believe is private. I couldn't make out words. I didn't need to. I went back to my book. I waited. At 11:04, she came into the study doorway and stood there for a moment. She was wearing the gray cardigan. She looked at me with those wet eyes that were already warming up, already preparing the performance, and she said, "Nate, we need to talk." I set down my book. She started talking. She said she had been scared. She said she hadn't known how to tell me this. She said that things had been difficult between us, and that sometimes when she tried to talk to me she felt threatened. The word came out carefully, like she had practiced it, which she had. She said she hadn't wanted to do this, but she didn't feel safe. She was good. I want to give her that again. She was genuinely, technically skilled at this. The eyes, the slight tremor in the voice, the pauses in exactly the right places. I sat and listened. Then she reached up and pulled the collar of the cardigan aside slightly to show me her shoulder. There was bruising there, a dark, ugly bruise against the pale skin of her upper arm. I did this, she said softly. I'm not going to pretend anymore that I didn't. I looked at her. I said, quietly, you should call whoever you're going to call Claudia. Something shifted in her eyes for just a fraction of a second. Just the slightest flicker of uncertainty, as if she hadn't been entirely sure I would hold this still, and my stillness was throwing off some small part of her calibration. Then she took out her phone and she dialed. 17 minutes later, the patrol car was in the driveway. The officers were polite, professionally polite, in the particular way that indicates they had been briefed, not on details, but on expectations. Handle this one smoothly. No complications. I understand now that Raymond Holt had personally arranged which officers were dispatched, which was a favor that was going to cost him considerably. They read me my rights. The young officer cuffed me. Claudia stood in the doorway performing grief. I looked at her once. I saw the twitch of satisfaction at the corner of her mouth. I got in the patrol car. In the car, I asked the officer driving, a woman, older, with watchful eyes, if I could make a phone call. She said not until we reached the station. I said that was fine. The station was 9 minutes away. I counted. At the intake desk, I was processed. Standard procedure. Name, date of birth, address, reason for detention. The officer at the desk was efficient, bored. He typed my information into the system, pulled up my record, started to enter the incident report. And then he stopped. I watched him stare at the screen. I watched his jaw tighten fractionally. He typed something else. Stared again. I could see from where I sat that something had flagged on his screen, though I couldn't see what. He excused himself, walked briskly to a supervisor's office at the back, knocked, went inside. Gerald had made some calls. Let me leave it at that. 22 years in federal prosecution leaves you with a specific and not inconsiderable network of people who know you, who know your reputation, who know that if your name appears in an arrest report, something is almost certainly wrong. Gerald had been discreet but direct. He had reached out to 3 specific people. That was all it took. The supervisor, a heavy-set man named Lieutenant Carver, who looked like he hadn't slept well in about a decade, came out and looked at me with an expression I recognized. It was the expression of a man who has just discovered he may be standing in the middle of something much larger than he thought. He said, "Mr. Calloway, I'm going to ask you to come with me." I said, "Of course." He led me to an interview room. It was a small room, which they always are. Cream walls, a metal table, fluorescent light humming slightly out of pitch. He offered me water, and I said yes, genuinely, because I was thirsty. He sat across from me and set down a folder that I gathered contained what the system had returned when my name was entered. He said, "Sir, I need to ask you something, and I need you to be straight with me." I said I would be. He said, "Are you the Nathaniel Calloway who served as senior litigation counsel in the Eastern District of Virginia from 1997 to 2019? I said I was. He closed his eyes briefly, like a man absorbing a piece of information he had been hoping might be wrong. "Mr. Calloway," he said, "the arrest tonight. Was this voluntary on your part? Meaning, did you allow this to happen?" I looked at him. I exercised my right not to resist a lawful detention while I allowed the legal process to play out as intended. He looked back at me for a long moment. "That's a very careful answer. I'm a very careful person." He nodded slowly. "There are some people who want to talk to you." They came in over the next 90 minutes. First Gerald, who arrived looking impeccably calm in a suit that suggested he had been awake and dressed since my call. He sat next to me, and we exchanged the kind of look that 20-year friendships reduce to a single glance. He was telling me everything was in motion. I was telling him I was fine. Sandra Mears arrived 40 minutes later. She had opened the package. She had made calls. She brought with her a colleague from the Civil Rights Division of the DOJ who handled law enforcement misconduct, a quiet man named Reyes who took notes on a yellow legal pad in small, precise handwriting and who said very little but whose eyes missed nothing. And then, 70 minutes after I arrived at that station, someone else walked through the door. His name was Arthur Kimball. He was 61, silver-haired, with the kind of posture that certain men develop when they've spent decades in rooms where posture is a form of communication. He was the director of the FBI's Washington field office. I had testified in front of his investigators 4 times in 22 years and had met him personally twice. He looked at me across the room with an expression I can only describe as professionally exasperated, in the way that a person is exasperated by something impressive. He sat down. He said, "Tell me about Raymond Holt." So I did. I told him everything. The voice memo, the timeline, the financial background, the internal affairs matter, the relationship with Claudia. I told him about Marcus Whitfield and the pre-planned divorce filing and the asset-free strategy. I walked him through all of it the way I had walked 100 juries through complicated conspiracy cases. Not dramatically, not performing, just calmly laying out each piece and showing where it connected to the next piece until the shape of the whole thing was visible. Arthur Kimball did not interrupt. He had that quality too, the ability to receive information without editorializing. When I finished, he was quiet for a moment. Then he looked at Reyes, who nodded very slightly. "Mr. Calloway," Kimball said, "you put together a better case against a sitting law enforcement officer in 4 weeks than some of my agents billed in 4 months. 22 years of practice," I said. "You let yourself get arrested." I needed everything official. I needed the charges on record, and I needed Raymond Holt to have committed to a position he couldn't walk back from. I paused, and I needed Claudia to believe she had won. He studied me. "And now it's your turn," I said. The arrest of Detective Raymond Holt happened the following morning. Sandra Mirza's office moved with the kind of speed that happens when a case arrives fully constructed, fully evidenced, and impossible to sit on. A federal arrest warrant was issued at 8:45 a.m. Holt was taken into custody at his desk at the sheriff's department at 9:18, in front of a bullpen of colleagues who watched in stunned silence as 2 federal marshals walked him out in handcuffs. The charges were serious: conspiracy to file a false police report, abuse of official capacity, evidence tampering in the prior narcotics case, which the opening of the conspiracy investigation had unlocked, obstruction of justice, the kind of charges that end careers and begin extended conversations with federal public defenders. Claudia was served with the criminal complaint that same morning at the house that was still technically half mine. Marcus Whitfield, who had driven over to begin filing divorce papers with the sublime confidence of a man whose client had already won, was present when the federal investigators arrived. He sat in my living room watching his entire morning's work become irrelevant with an expression of barely contained professional horror. The internal affairs investigation into Holt that had apparently been resolved suddenly and conveniently in his favor was reopened by the state attorney general's office. My contact there called me that afternoon to say she was sorry she hadn't asked more questions when I had approached her the first time. I told her she had given me exactly what I needed. I want to tell you about the moment I learned that Marcus Whitfield had actually advised Claudia to destroy the voice memo. He had apparently told her, weeks before the arrest, that she should delete the recording and that its existence was her greatest liability. She had told him not to worry about it. She said she would handle it. She hadn't. She had forgotten about it the way people forget about the details they don't consider dangerous. That voice memo was the spine of the entire case. She had kept it on the household Bluetooth account for 7 weeks. The trial, and when I say trial, I mean Claudia's trial, because Raymond Holt did not go to trial. He pleaded guilty to 4 of the 7 charges within 6 weeks of his arrest and received a sentence of 8 years. Claudia's trial was the kind of thing I had witnessed 100 times from the other side of the courtroom, and that had a completely different texture when it was personal. She had a good lawyer, not Whitfield, who had quietly withdrawn from her representation under circumstances he declined to publicize, but a genuinely skilled defense attorney named Harrigan who tried hard and pushed every angle she could find. The false injury claim was the centerpiece of the prosecution's case, and what came out during testimony was that the bruising Claudia had shown me had been self-inflicted with a technique she had apparently researched extensively. There was search history on her laptop that made the jury visibly uncomfortable. A forensic medical expert testified about the pattern and positioning of the bruising and explained precisely why it was inconsistent with the scenario she had described. The voice memo, played in open court, was the end of it. Her own voice, calm, practical, plotting. The jury listened to 2 minutes and 43 seconds of that recording and deliberated for less than 3 hours. Guilty on all primary counts: conspiracy, filing a false police report, perjury. The judge at sentencing made a point of saying, from the bench, that the deliberate targeting of a law enforcement official's reputation, meaning my professional history, as a mechanism for the conspiracy elevated the severity of the conduct. She received 5 years. I was in the courtroom for the verdict. I watched her face when the foreperson read the word guilty. It did not give me pleasure, exactly. It gave me something more complicated than that. A release, maybe, of something that had been held tight for a very long time. The particular feeling of a door closing that needed to be closed. She looked at me once, across the courtroom, before they let her out. I looked back. I didn't say anything. There was nothing to say. Everything had already been said in that courtroom, and the 47 words on the jury verdict form had said it more precisely than I ever could. There are things you don't expect when something like this ends. You don't expect the quiet. You've been living at such a specific and concentrated pitch of alertness for so long. Gathering, watching, preparing, waiting, and then it's over, and the house is silent in a way it wasn't before, and you have to figure out what to do with that silence. I sold the house in the spring. It was the right thing. It had stopped being a home some time before any of the visible events of this story, and staying in it would have been the wrong kind of loyalty to the wrong version of my life. I bought a smaller place, a good place, a house with a big study and windows that face east so I get light in the morning. Horace the dog died 2 months after the trial. 14 years old. He had been slowing down for a while. I was with him when he went, which I'm grateful for. I cried more about that than I cried about any of the rest of it, which probably tells you something about where my feelings actually live through all of this. I went back to work, not as a prosecutor. That chapter was finished, and I had no desire to reopen it. But I had been approached, shortly after the trial, by the law school at a local university about teaching. Evidence, federal procedure, criminal law. I said yes, mostly to have something to do, and I discovered inside the first semester that I was genuinely good at it, and that the students, most of them wide-eyed and ambitious and slightly terrified of me in the productive way, were good for me. There is something clarifying about explaining the law to people who have never been jaded by it yet. I teach a seminar now on wrongful accusations and evidentiary standards in domestic violence cases. The irony of that is not lost on me. I address it directly on the first day of every semester. I tell the students that I have a personal interest in the subject. I tell them the broad strokes. I tell them that the law is a tool, and like any tool, its virtue depends entirely on the integrity of the hands that hold it. They listen very carefully when I say that. Raymond Holt is serving his sentence in a federal facility in Pennsylvania. I understand that he has been isolated from general population for his own protection, which is standard for law enforcement officers in federal custody. He filed a civil motion against the county sheriff's department in his first year inside, which was dismissed. I do not think about Raymond Holt very often. He was a man who made a series of choices that compounded on each other until they became catastrophic, and I have seen enough of those stories to understand them without having to carry them. Claudia will be eligible for release in approximately 2 years. I have had no contact with her since the trial. I don't have feelings about this that I can accurately articulate, not anger, not grief, not even the particular complicated warmth I feel for things that used to matter to me. More like the absence where a feeling used to be. Clean, in its way. What I think about, honestly, more than any of the rest of it, is the gray cardigan. Not in a tormented way. Just, it's a specific detail, and specific details are how I have always understood things. I think about the fact that she was wearing it, that night on the porch, that she had chosen it. Maybe deliberately, maybe not. A familiar thing. A soft thing. A thing that had existed in the comfortable earlier chapter of our life together. And she had wrapped herself in it to stand there and watch me led away in handcuffs, with satisfaction in the corner of her mouth and grief performed precisely in her eyes. There's something in that image that tells me everything I ever needed to know about the gap between the life I thought I was living and the life I was actually in. I don't regret being patient. I don't regret doing it the right way, building the case, letting it develop fully. Some people have asked me, friends, colleagues, even a few students who know the story, whether I was tempted to just confront her, to just lay everything out, to say, I know, I've known for months, let's stop pretending. The answer is no. And not because I'm cold or detached, or because confrontation scares me. The answer is no because I understand what evidence does. Evidence doesn't just win cases. Evidence removes doubt. It closes off the exits. It forecloses on the possibility that a guilty person can rewrite the story after the fact. If I had confronted Claudia privately, she could have destroyed the voice memo, covered her tracks, painted whatever picture she wanted of a marriage falling apart and a husband who became unstable. She could have gotten to Raymond Holt, warned him, let the whole conspiracy dissolve quietly into a difficult divorce where nothing could be proven and everything could be disputed. By letting it play out, by letting them commit fully to a position, by creating official records, by ensuring that the arrest and the charges and the entire performance were documented and real, I made it impossible for any of them to walk it back. That is what patience buys you, not satisfaction in the moment, the ability to make the truth permanent. I think about my 22 years in that office sometimes, and I think about what it all was in the end. All those cases, all those courtrooms, all those hours building arguments that I believed in with my whole professional self. I gave a lot to that work, more than most people understood from the outside. And I think the thing I'm most grateful for, sitting here on the other side of all of this, is that all of it, was the exact preparation I needed for the most important case I ever had to build. The one that started at 11:17 on a Tuesday night with a knock at my own front door. The one where the only person I was protecting was myself. I am not a man given to dramatic statements. I've spent too many years in rooms where language is a precision instrument to trust grand pronouncements. But I will tell you this, and I mean it as plainly as I know how to say it. The people who tried to take everything from me did not fail because of luck. They did not fail because of coincidence. They did not fail because some force in the universe decided fairness mattered. They failed because they looked at a quiet man and assumed quiet meant weak. They failed because they built their plan on a version of me that had never been real. They failed because 22 years of the best work I ever did turned out to be a masterclass in exactly what I needed to do when they came for me. And when the young officer snapped those handcuffs onto my wrists at 11:17 on a Tuesday night, two tight, slightly trembling hands, doing his job as he understood it, I let him. Because I knew something that no one else on that porch knew. The case was already built. The truth was already documented. And all I had to do was wait for the courtroom.